Hello, everyone. We have another update on SafeMoon. These are court documents, and this is going to be shared via Live for a Ford. Primarily, we do have this post here I want to start with from DeFi Stella, and they actually said the original image courtesy was thanks to Systems TNG. And in this court document, what you guys can see is that it's filed December 17th, 2023. And the key area here that we're going to be actually reading through anyways, but to really focus on is this section that says liquidity pools and crypto assets need to be managed, wound down, and liquidated. Okay, I want to say that one more time. It's really important. Liquidity pools and crypto assets need to be managed, wound down, and liquidated. So I know there's some of you guys that are out there that still believe in SafeMoon, that it's going to bounce back. This is another nail in that coffin that if you continue to keep ignoring this, I don't really know what else you can hear to ever change your mind. Let's go ahead and read through the document now. This is going to be quite lengthy. I wanted to start with that element, but there's a lot of stuff that's here. Okay? I'll try to read through this as quickly as I can for you guys. Before I get started, I am on TikTok at Crypto Atlas. I'm also on TikTok at AI.crossover. You can find a link to that down in the description below. I would really appreciate it, would love it if you guys would follow me on TikTok. Okay, here we go. In the United States Bankruptcy Court for the District of Utah, motion of Ellen E. Ostro, Chapter 7 trustee, for an order pursuant to the code authorizing the Chapter 7 trustee to operate the debtor's business on a limited basis effective as of the petition date for the sole purpose of liquidating the business and employing the debtor's former employees as independent contractors and to pay for services, and B, for additional relief. Quick side note, I did do another video earlier today on SafeMoon that had to do with the delisting for an exchange. If you guys want to check out that video, I do have that up already. Ellen E. Ostro, the trustee, the duly appointed trustee, is the above entitled Chapter 7 bankruptcy case. The bankruptcy case filed by SafeMoon US LLC, the debtor, by and through her undersigned proposed counsel, hereby submits this motion, the motion for entry of an order substantially in the form attached hereto as Exhibit A, pursuant to Sections 11 U.S. Code. It gives you the code. The bankruptcy code authorizing the trustee to A, operate the debtor's business on a limited basis effective as of the petition date as defined below for the period of up to 60 days for the sole purpose of winding down the business, and B, employing and paying the debtor's former employees for their services. In support of this motion, the trustee respectfully represents as follows: jurisdiction venue. Number one, this court has jurisdiction to consider the application pursuant to, gives the code. This is a court proceeding under, gives the code. Venue is proper before this court pursuant to another code. Number two, the statutory basis for the relief requested herein are section, gives you the sections and title of Title 11 of the United States Code. Background: on December 14th, 2023, the petition date, the debtor filed a voluntary petition for relief under Chapter 7 of the Bankruptcy Code. Ellen E. Ostro has been appointed as Chapter 7 trustee. The Section 341A meeting of creditors is scheduled for January 17th, 2023. I'm believing that they meant to put 2024 because we're already at the end of 2023. Prior to ceasing operations, the debtor was a cryptocurrency and blockchain company based in Pleasant Grove, Utah. The debtor was created in March 2021. Concurrently with its inception, the debtor created and sold a SafeMoon token, SFM token, that trades on the BNB chain Binance blockchain. The value of the SafeMoon token increased exponentially in its first month of existence, resulting in the total market value of the token rising to the billions of dollars in April 2021. Over time, however, allegations that the debtor's principals made misrepresentations and engaged in other alleged misconduct led to a sharp reduction in the market price of the SafeMoon tokens. On February 17, 2022, Certain individuals filed a class action complaint against the debtor, Braden John Crony, the debtor's former CEO, Kyle Nagy, the debtor's founder, and various other executives and or insiders of the debtor in the United States District Court for the District of Utah. The class action complaint gives you the case number. In the class action complaint, as it has been amended, the plaintiffs allege that the debtor and other defendants violated, among other things, Section 10B of the Securities Exchange Act of 1934, the Exchange Act promulgated thereof, and various other federal and state laws by making false statements of material fact and engaging in a scheme to defraud investors relating to the purchase or sale of a security, i.e. the SafeMoon token. On November 1st, 2023, the Securities and Exchange Commission filed a complaint against the debtor and others in the United States District Court for the Eastern District of New York. It's the Securities and Exchange Commission versus SafeMoon LLC et al. And gives you the case number. In the SEC case, the SEC asserts various claims against the debtor and other defendants under the Exchange Act Rule 10b-5-5 and the Securities Act of 1933 gives you the code. Relief requested, 10. The trustee anticipates that she will engage former employees of the debtor to assist her administering the Chapter 7 case, including, among other things, A, assisting in liquidating crypto assets as they have historical knowledge about the assets that will be subject to conversions to cash, B, selling the debtor's assets, and C, managing and protecting liquidity pools. The trustee has filed the motion seeking authority to A, operate the debtor's business on a limited basis and for the sole purpose of liquidating the business, and B, hiring former employees as independent contractors to perform the services based on the trustee's discretion. The scope of this motion is therefore limited. The trustee has not and does not intend to operate the debtor's business in any other manner beyond the limited manner set forth herein, which will enable the trustee to appropriately discharge the trustee's duties and maximize value for creditors. The trustee should be authorized to operate the debtor's business on the limited basis set forth herein under the code. The trustee, in the exercise of her business judgment, believes the best way to maximize the value of the debtor's assets is to operate the debtor's business on the limited basis we set forth in this motion to sell the debtor's assets, liquidate substantial crypto assets, including liquid cryptos such as Bitcoin and Ethereum, and convert them to cash and manage liquidity pools. Therefore, the trustee is requesting authority to operate the business on a limited basis for the period of up to 60 days without prejudice to the trustee's rights to request additional time to the extent it may become necessary to do so. The trustee respectfully submits that the relief requested is designed to maximize the value of the debtor's assets and that it is fair and equitable under the circumstances of this case. Section 721 of the Bankruptcy Code provides that the court, quote, may authorize the trustee to operate the business for a limited period of time. The Bankruptcy Code allows bankruptcy courts to authorize a Chapter 7 trustee to operate the debtor's business for, we continue on here, a limited period of time. If operation of the business is in the best interest of the estate and consistent with an orderly liquidation, the trustee submits that the operation of the debtor's business on a limited basis in the form of winding down the operations and hiring former employees as independent contractors to assist in the liquidation of the debtor's assets is in the best interest of the debtor's estate and is consistent with the orderly liquidation of the debtor's estate. Liquidity pools and crypto assets need to be managed, wound down, and liquidated. Obtaining authority under the code provides the trustee with maximum flexibility to accomplish those tasks in the best interest of creditors. Moreover, the trustee, in the exercise of the trustee's business judgment, believes that hiring former employees will maximize the value of the debtor's assets for all interested parties. If the trustee is not authorized to hire certain of the debtor's former employees, there would be a loss of significant value to the detriment of the debtor's estate, since those former employees have valuable knowledge of the debtor's business. The trustee also reserves the right to request additional time to operate pursuant to Section 721 should the need arise based on the circumstances of the case. The trustee submits that further extension of the authority to operate as set forth herein is permissible under the code. The authority of a trustee to operate the debtor's business can be renewed periodically by the bankruptcy court if the continued operation of the debtor's business by the trustee remains consistent with the requirements of Section 721 of the code. Down below here, the footnote we have, notably, the trustee is not marketing SafeMoon tokens she is winding down the business in a reasoned, managed way. B, the trustee should be authorized to employ former employees of the debtor as independent contractors. The trustee has identified former employees of the debtor to assist the trustee with the winding down of the operations. Although the trustee will be actively engaged in the liquidation and administration of the estate, the former employees are thoroughly knowledgeable in the debtor's operations and would be valuable assistance to the trustees throughout this process. The trustee proposes to compensate certain of the debtor's former employees that the trustee decides to hire in her business judgment as independent contractors, including through A, paying their pre-petition claims up to the priority cap under the code, and B, paying such employees for services going forward at their pre-petition salaries plus 15%, in order to incentivize such employees to stay in what is a short-term terminal position. Section 105A of the Bankruptcy Code provides that the court may issue any order, process, or judgment that is necessary or appropriate to carry out the provisions of this title. No provision of this title shall be construed to preclude the court from, sua sponte, taking any action or making any determination necessary or appropriate to enforce or implement court orders or rules. Section 105A has been interpreted to expressly empower bankruptcy courts with broad equitable powers to, quote, craft flexible remedies that, while not expressly authorized by the code, affect the result the code was designed to obtain: official communications of unsecured creditors. Another footnote here: the trustee cannot provide the names of the former employees for the sake of their safety. If the trustee reveals their names, some employees will leave the operations of the debtor. So this continues on. Although not limitless, this section has also been construed to give bankruptcy courts authority to provide equitable relief appropriate to assure the orderly conduct of bankruptcy proceedings. Under Section 704A of the Bankruptcy Code, among other duties, the trustee is required to A, collect and reduce the money the property of the estate, be accountable for all property received, investigate the financial affairs of the debtor, and furnish information concerning the estate and the estate's administration requested by the parties in interest. To satisfy these statutory duties under Section 704A, which also operating the debtor's business on a limited basis under Section 721 is set forth in the motion, the trustee believes that Section 105A provides the court with the power to authorize employment certain of the debtor's former employees as the trustees at the trustee's discretion in the limited operation of the debtor's business. In addition, Section 363C provides if the business of the debtor is authorized to be operated under Section 721 of this title, and unless the court orders otherwise, the trustee may enter into transactions, including the sale or lease of property of the estate, in the ordinary course of business without notice of a hearing, and may use property of the estate in the ordinary course of business without notice or a hearing. The trustee submits that the authority sought in this motion would fall within the ordinary course of business of the debtor for purposes of Section 363C, and the trustee may use estate assets to fund the limited operations described herein in accordance with Section 363C of the Bankruptcy Code. Finally, the trustee requests that any payments for post-petition services to such independent contractors retained by the trustee should receive administrative expense status pursuant to section, gives you the code of the Bankruptcy Code. Another code of the Bankruptcy Code defines administrative expenses as including, quote, the actual necessary costs and expenses of preserving the estate, including wages, salaries, or commissions for services rendered after the commencement of the case. The principal purpose of section, gives you the section, is to induce entities to do business with the debtor after it files for bankruptcy by ensuring that those entities receive payments for services rendered. For an expense to qualify as administrative under this standard, it must, number one, be an expense, two, that is actual and necessary, three, to preserving the estate. The cost or expense must arise from a post-petition transaction with a trustee, and the consideration supporting the right to payment must have directly and substantially benefited the estate. Priority is granted to compensate the providers of necessary goods, services, or labor. In particular, wages for post-petition services qualify as administrative claims entitled to priority under section, gives you the section. Those expenses for wages, salaries, or commissions incurred post-petition in an effort to preserve the estate or operate the debtor's business qualify as administrative expenses. As part of their duties in administrating the estate, Chapter 7 trustees often need the services of employees to operate, manage, or assist in winding down the debtor's businesses. Necessary to preserve the estate, the trustee or debtor in possession may hire employees to operate, manage the debtor's business. Employees may include the debtor's former personnel or the individual debtor. In addition, retaining or hiring employees is often necessary in liquidated Chapter 11 plans and certain Chapter 7 liquidations. To induce those former employees to serve post-petition as independent contractors and help operate the debtor's business on a limited basis. Payment for such services should qualify as an administrative expense entitled to priority under section, gives you the section of the Bankruptcy Code. The trustee believes that the proposed payments to the independent contractors for the proposed post-petition services should be entitled to administrative expense priority under the code because such services are expensive, that are actual necessary, preserve the debtor's estate, mentioned above. Former employees for post-petition work independent contractors. In operating the debtor's business will reduce the practical burdens of learning the debtor's businesses by having those most familiar assist the trustee with access and providing needed information, operating the business on a limited basis. In turn, this arrangement preserves the debtor's estate and maximizes value for all creditors by reducing the time and costs associated with hiring outside personnel to perform the same services. So, I mean, it's basically just restating the same thing a lot of different times. I hope you guys can pretty clearly understand what they're talking about here. Notice that this motion has been given to the following parties or in lieu thereof to their counsel, if known, the Office of the United States Trustee, Counsel of the Debtor, and upon all parties who have requested notice pursuant to Rule 2002 of the Federal Rules of Bankruptcy Procedure, the trustee submits that in light of the nature of the relief requested, no other or further notice need to be given. No prior request for the relief sought in this motion has been made to the court or any other court. Wherefore, for the reasons stated herein, the trustee respectfully requests that the court grant the relief requested in the motion, enter the proposed order, and grant such others and further relief as the court deems just and proper. That was dated for yesterday, technically. And then it says, Certificate of Service. I hereby certify that on the 17th day of December 2023, a true and correct copy of the foregoing motion of Ellen E. Ostro, Chapter 7 trustee, for an order pursuant to the code authorizing the Chapter 7 trustee to operate the debtor's business on a limited basis effective as of the petition date for the sole purpose of A, liquidating the business and employing the debtor's former employees as independent contractors and to pay for services, and B, for additional relief, was electronically filed and therefore served via ECF on the following. All right, guys, that does it for this video. Let me know what you guys think about this down in the comments below. Thank you so much to my Patreon supporters. Double shout out. Thank you to We Love, Victor Vegas, SafeMoon X for being higher level patrons. Thank you to my YouTube members for your support as well. God bless, and we'll see you in the next episode.